that use as unpublished work be deemed fair. The third is the amount and substantiality of the portion used, and that basically says how much of the original work is being used. Is it a paragraph from a novel, which would be very likely a fair use, or are you using 3 chapters from it? Are you using a 30-second clip from a movie or the whole third act? Basically it looks at how much you're using of the original work. And the fourth factor is the effect of the use upon the potential market or the value for the copyrighted work. And that basically that asks that transformative question that I just mentioned previously. This work, is it meant to replace the original? Is it going to hurt the market for it? Or is it something that's going to exist completely separate from it? Or is it possible that this use of the content might actually improve the market for it? So, and most of the time, in most fair use cases, the first and the fourth factors, the nature and character of the use and the effect upon the potential market, those are the two that are given the most weight, though all four are considered.
Many, many blog producers have articles all over their page. And a lot of the articles are not necessarily articles they personally wrote. They're posted. And I've seen this a lot, where you go to somebody's site, it's like a clearinghouse for all these articles about X, whatever that subject is.
Yeah.
And what they do is they're taking actual articles from all these different places and posting it as a clearinghouse on that site. So it's not like they write 50 or 75 words and then there's a link to that thing.
Yeah, exactly. They're doing the whole article.
Explain what that is. What does that mean?
Well, from what you describe, obviously without seeing the site, can't say too much, but it sounds like that would be a copyright infringement. They are unlawfully and without permission taking the work, copying it, and redistributing it on their site. That would be a copyright infringement, and those copyright holders, if motivated, could, depending upon what they wish to do, could either file cease and desist notices, takedown notices, or even potentially sue over it. And we're actually seeing an increasing number of lawsuits over this type of article aggregation right now.
So one of the things that you do at Copybyte is go through people's sites and assist them to make sure that they're in compliance, correct?
Yeah.
Now, let us suppose that you have well-meaning people that are not in compliance, and they have to repurpose that website. What can your company do for them?
Well, what we do in those situations, a lot of times, we advise people that these articles have been listed, these are fine. It starts with a basic analysis of the content. You go through, you look at everything, you find what's in violation, what might be in violation, and what's in the clear, is the idea. And you advise that if they have to keep those articles that are violating, that they truncate them, that they do kind of what you described just a little while ago, where they take like maybe the first paragraph and then throw a link out to the actual site. And a lot of great social news sites do this very well right now. You look at sites like dig.com, Reddit, sites like that. They do a very good job of showing the content, of linking out, using excerpts, and generating a lot of traffic and being great clearinghouses on some very interesting subjects. So you don't have to, and it shows that you don't have to have all the content directly on your site in order for it to be a clearinghouse, in order for it to be useful to visitors. And in many ways, it's more useful for them to get the content on the original sites.
I know that a lot of people have an issue with people leaving their site, but it actually is a good thing. In other words, where you go to somebody's site, they have some type of a very important article or a very useful article, and you read a little bit about it, and then you click over and you read the original article. A lot of people are scared if people leave their site that they're losing their visitors. That's not true, is it?
I don't think it's true. Certainly not as much anymore. I think it was more true before tab browsing became very, very common. I mean, these days, if I want to stay on one site and click a link that I know is external, I'll, command click or right click and open to a new tab. The idea is, we, through tab browsing, the browser evolution really, have the ability to stay on one site and visit another and close out and come right back. So I don't think the issue of losing visitors is that bad anymore. And there's always the back arrow, which they were probably going to have to use anyway. So, yeah, it might be a page view that's lost in terms of they're not viewing the original article on your site. But given the headaches legally that article and that one page view can cause, it's just not worth it.
Let's talk about photos. Videos are obvious. Even audios are obvious. I've seen sites that actually take my shows and post them on their sites. I don't mean links to the show, but actually post them on their sites. I've seen people take my shows and start selling it without permission and just doing it and doing their own thing. But what about images? Let's suppose that somebody has my image on their site. Let's say they take the image from It's Rainmaking Time of Kim Greenhouse and they post it on their site. Is that a violation?
Yes, absolutely. Images have the same protection as audio, video, and text. Absolutely.
Very interesting. So this is in all realms.
Yeah, this is basically copyright protects all works of creative authorship fixed into a tangible medium of expression. So that includes all writing, pretty much. It protects images. It protects audio. It protects video. It even protects programming code. For example, the HTML and the CSS code of your site is protected.
Really?
Maybe not the general look and design, that kind of intangible design, but the actual code is protected as long as you're the one who created it. So yeah, I mean, that's how you see things like WordPress that are licensed under the GPL. The reason they're able to have copyright licenses is because that code is copyright protected. They just choose to distribute it and license it more freely. But so yeah, you have protection over the code you write for your site, and you have general protection over pretty much anything that fits that descriptor.
Is that true with themes as well? And how do themes, like, for example, with WordPress, how do themes function then under GPL?
There's actually still a huge debate about that, and I know wading into this, I'm going to get my head blown off one way or the other. One side or the other is not going to like me.
You can give your own sense of where you think it's complex and where you think it's clear.
Yeah, that's what I think is going. Well, I think the deal is this. With themes, there are multiple parts. Now, the idea of GPL is that if you use GPL code to write other code, so if you kind of made a derivative version of WordPress and called it SnerdPress or something, I have no idea what you would call it, that new version of it would be GPL, because you're using it under the GPL license, and therefore anything you create based upon it is GPL licensed. And that comes with it certain terms and restrictions and so forth.
What does GPL mean?
Well, GPL stands for the GNU Public License. And basically, it's a license that means that you are free to use this code for just about any purpose. You can download it, you can distribute it, you can even sell it. You can do pretty much anything you want with it. But when you distribute it, or you distribute anything based upon it, it has to be licensed under the same terms. And in that regard, it makes the license viral. So like I said, if you make a modification to WordPress and you distribute it, it only takes effect when you distribute it. Not if you keep it just on your computer, but when you distribute it or push it out into the world.
Right.
That code you distribute is GPL licensed too. And that makes it viral and makes sure that, the idea is they don't want anyone to take GPL code, make modifications to it, and then lock down their modifications from the community. They want to make sure that everything born from GPL software goes back to it.
Got it.
That's the idea.
Is GPL the same as open source? Does it mean the same thing?
Well, open source is a collection of licenses, and that does include GPL license. So it's yes, in a big way. And the GPL, I think, is the most popular one, but it also includes other licenses like the Apache license, the Mozilla license, and so forth, which from a practical standpoint are very much similar, but from more of a technical standpoint, oftentimes have key differences that make them incompatible. So from more of a legal standpoint, but as far as like our perspective as an end user, very much the same effect. So, like going back to the themes thing, whenever you build a theme, there's multiple parts to that theme. There's PHP files which bring in WordPress code to build the theme. You stick in the various hooks, what they call them in WordPress, in the theme in order to make the theme work. And there are other elements too, like the CSS files, the images that go with it, etc., that don't involve WordPress code. And I think the consensus that they automatically got when they asked for an outside consultation on this, and kind of my own personal consensus, is that there are parts of the theme, those PHP files that integrate WordPress code, probably need to be GPL licensed. But the images and the CSS, which kind of stand alone and can function on their own, probably